then also to give you our own personal comments about some of the legal and cultural and social issues related to these executive orders. So my job right now is to identify and just to give you some bullet points information about the executive orders, and then I've asked each of the speakers to provide some specific comments. We will then open it up to a Q&A. I imagine that there are a lot of questions that will be presented from the audience. Each speaker will have 4 minutes, and we will try to stick to that time to make sure that we have a robust conversation. So first, there were 3 executive orders that were issued by President Trump. They were, the most recent one is protecting the nation from foreign terrorist activity into the United States. That was issued on January 27, 2017. A few days before that, he issued 2 executive orders, one called Enhancing Public Safety in the Interior of the United States, and the other one is Border Security and Immigration Enforcement Improvements. Let me talk briefly about each one of them. So first, one deals with the issuance of visas, protecting the nation from foreign terrorist activities. The goal of this particular executive order is, as stated, to protect against terrorism, right? According to the executive order, there were links, there were big tragic events such as 9/11 justifies a type of executive order that would limit the issuance of certain visas of foreign nationals coming to the United States. So then the executive order suspends the issuance of visas for 90 days from these 7 countries: Iraq, Syria, Iran, Sudan, Somalia, Libya, and Yemen. The executive order also suspends entry of all refugees for 120 days, but except Syrians. There's an indefinite ban on refugees from Syria. There are, after the suspension of the refugee admissions, the executive order provides that only 50,000 refugees will be admitted to the United States, and there will be preferences for those coming who are minority, who belong to minority religions in a majority, in a particular majority religion country, and we'll talk some more about what that means. The second executive order deals with enforcement of immigration law within the interior of the United States. Here the goal is to enhance the enforcement of immigration law, typically done by ICE, but also by state and local governments when they engage in what's called, or enter into what's called 287G agreements. So some of the key points from this particular executive order. It sets forth new priorities with respect to who will be prioritized for removal as well as detention. Some of those, as will be discussed later, includes non-citizens who have had certain brushes with criminal law, as well as those who are suspected of terrorism. Increased prosecution of illegal entries and re-entries by the U.S. Attorney's offices, and also the reinstatement of what's called secure communities, which again is a type of federal enhancement of detention and removal of certain non-citizens. Also, the executive order enhances the ability of state and local governments to cooperate with the United States government, but at the same time punishes those cities that call themselves sanctuary cities or provide sanctuary havens to undocumented immigrants. The executive order seeks to defund these sanctuary cities. And finally, the executive order provides some greater protection at the border, right, in creating a wall. So those are different examples of what the wall or the fence currently looks like, and also increasing the number of detention facilities we have in the United States. Some key aspects of this provision, of this executive order: build the wall, right, relying on the Secure Fence Act that was passed by Congress several years ago in order to get appropriations to build, to construct, and enter into agreements with private organizations to construct a contiguous wall in the southern border. It also requires foreign aid reporting requirements, as in determine how much the U.S. government gives in aid to Mexico, as a way to determining how much money Mexico might be able to pay for this wall. And then finally, this executive order increases the number of detention facilities in the United States, as well as the ability of ICE to detain non-citizens who enter here illegally by also increasing the number of Border Patrol agents. And according to the executive order, it's designed to end the abuse of the asylum system. So those are, in 4 minutes, I think, are the main points of the executive orders. I did not cover every single part of it, but we're happy to address some of your questions during the Q&A. Okay, so I'd like to thank the Aoki Center for Critical Race and Nation Studies, Immigration Law Association, La Raza Student Association, and the Middle Eastern South Asian Law Students Association for sponsoring this event. Let's now turn to a conversation and hear remarks from our panelists. So let's first talk about the suspension of issuance of visas. Professor Saucedo, can you give us some historical context here and some of the legal basis for why the executive order of issuance of visas, what the federal government thinks is the reason why they needed to pass this law?
So part of what I want to talk about is the rhetoric behind the orders, especially the order on the issuance of visas, because I think that the federal government, or at least the executive branch, is relying on broad plenary authority of the federal government to implement some of these executive orders. Personally, I think that it's much broader, an overreach of the plenary authority that already exists. But as early as the late 19th century, the government was given broad plenary authority, or broad authority over immigration regulation in a case called Chai Chang-ping versus United States. And there, the federal government excluded Chinese from the United States, Chinese laborers, and the Supreme Court upheld the exclusion based on this plenary authority. I think it's this kind of plenary authority that the executive branch is depending on now. The problem with the authority is the rhetoric that the federal government is using now is to say that they want to ensure against people entering the United States who do not bear hostile attitudes towards the United States. And I think this is effective rhetoric that does conjure up this need for safety and security, which have always been the sort of underlying rationales for broad authority. But immigration law has evolved since Chai Chang-ping to focus on specific past acts or other behavioral evidence of past acts, right? And away from states of mind like hostile attitudes. I think the federal government at this point is using cases like Chai Chang-ping and deference to the federal government, along with this rhetoric, in order to create overly broad executive orders. The other form of rhetoric that it uses is that it says that the United States should not admit those who engage in acts of bigotry or hatred, including honor killings or other forms of violence against women. Again, this is setting up this rhetoric of the executive branch as this almighty protector of victimized subjects, but this is the same rhetoric that had been used to establish plenary power under the Chinese Exclusion Act. And we can see shades of it early in the late 19th century when the Chinese Exclusion Act was being debated. There were all kinds of advocates that were producing images of poor Chinese women who were being trafficked into the United States, and this was one of the rationales for the Chinese Exclusion Act. I just want to add really quickly that I think that the rhetoric is dangerous in that it starts with this purpose that's based in safety and security, but ends up with a really, really broad net. And so the executive order ends by saying, we want to develop a process to evaluate the applicant's likelihood of becoming a positively contributing member of society and the applicant's ability to make contributions to the national interest. Those are standards that have been usually used in immigration law, historically used in immigration law, as ways to waive people who are inadmissible into the country, right? So we've moved now from a standard for people who are inadmissible to a standard that's going to be used for everybody who seeks entry into the United States. And I think that's part of the danger of relying on this strong deference to the federal government and having it end up with a very broad provision that encompasses everyone.
Thank you. Next, let's turn to, let's connect some of this history and the rhetoric and invocations of certain of the plenary power doctrine to constitutional law questions and what might be the legal arguments that can be placed against this particular executive order. And to help us with that, we have Professor Brian Soucek. So one of you two.
So the last time I looked, there were 50-some lawsuits that had been filed. This was last Friday, so it's dated information. I don't know what the number is by now. They're growing by the hour. I've been teaching for the last hour, so who knows what it is right now. But 50-some lawsuits that have been filed against the January 27th order, the visa, the travel ban, and the suspension of the refugee program. The biggest, latest news on the lawsuits comes first from Boston, where the federal court sitting in Boston last Friday said that it was not going to extend the temporary restraining order that had been put in place during the first weekend of the ban. The judge, in doing that, rejected all of the constitutional and statutory arguments that had been raised in that case. Some of them, like the ones brought by the green card holders, had been mooted out, given more recent developments by the administration saying that the ban would not be applied to green card holders. But others were just rejected, or rather the judge in Boston found that there was not a likelihood of success on the merits. For equal protection, establishment clause, due process, Administrative Procedure Act, and free speech claims. However, the same day, a judge in Seattle issued a temporary restraining order, which has now frozen the ban, frozen basically the entire order, and has done so nationwide. That's currently on appeal at the Ninth Circuit on a highly expedited briefing schedule. Briefing should be done in about 3 hours. You've probably read this morning about the variety of amicus briefs that have been filed, some by people sitting at this table, others by some of our biggest tech firms, and some major national security officials from from former administrations. One major question that's come up from the Seattle injunction is about its scope. This case was brought by the state of Washington and the state of Minnesota. The state of Hawaii has an emergency motion to intervene at the Ninth Circuit. They're claiming that they have arguments that the other two states are not making, and also that Hawaii is differently situated in terms of being an island and people needing to fly, and also in terms of its cultural makeup. So not only are there interesting and problematic standing issues about the states standing to bring these kinds of claims, but there are also important procedural questions about the scope of the injunction and whether it can apply or should apply nationwide, as it's currently doing. In arguing for a nationwide injunction, the state of Washington adopted arguments that it had previously opposed when made by Texas a couple years ago, as Texas challenged President Obama's executive orders in DAPA. There, the claim was that because this is immigration law and immigration law affects the country as a whole, any injunction affecting immigration law needs nationwide scope and can't just be limited to the states. Okay, so what are the claims that are being raised? Well, there are statutory claims. There are claims that say that the president's discretion over he has the discretion to suspend the entry of any aliens, class of aliens that he deems appropriate. But there's also in the same law a non-discrimination provision that applies to immigrant visas and bars discrimination on the basis of race, sex, or nationality. Question is how those two clauses of the Immigration Nationality Act fit together. Which one trumps which, in other words? That's a major question going forward. There's also a question about whether the 212F, the power that the president is relying on to do this, is a broad enough delegation to allow the president to basically remake immigration law. This is the claim being made by Hawaii, that he does not have that broad of a power. Another statutory claim is from the Religious Freedom Restoration Act. This is a statutory religious freedom protection. This would almost certainly need to be made by somebody here in the US, but if somebody could show that their religious exercise has been substantially burdened by this act, that would force the federal government to basically survive strict scrutiny in showing why the limitations here were needed. On the constitutional side, there are both free exercise and establishment clause claims. The free exercise claims are basically the same as an equal protection claim on the basis of religion. So we've got discrimination claims both on national origin for the travel ban, the visa part, and then for religion, which is clearest on the part of the refugee suspension, because not only does it suspend all refugee admissions for the next 120 days, but it says that now and going forward there should be priority given to religious minorities in the country of order. People who are persecuted on the basis of their religion as long as they are religious minorities in the country from which they fled. The claim is that privileges one sect over another, which is what the Establishment Clause is meant to prohibit. Finally, there's a due process argument that especially regarding the visas, that they were being taken away, canceled without adequate process. The standard here, the minimum standard here seems to be that the regulation needs to be facially legitimate and bona fide. That's something that's been very directly challenged in the Washington litigation, whether there is any kind of facially legitimate reason either for the 7-country travel ban or for the suspension of the refugee provisions. Final comment, just a lot of these claims are going to vary both on the basis of who's making them. So people with more of a connection to the country, people who are here already, for example, on a travel visa, student visa, versus somebody who's outside the country currently. Constitutional protections will likely vary based on your status there. And finally, the major question will be, since, for example, the religious discrimination isn't facially in the words of the executive order, to what extent courts are willing to go beyond the words of the order in order to look at tweets and other statements made by the president and others that might reveal some different motivations.
Thank you, Professor Soucek. Professor Harris, can you give us your views on your views about the executive order, this particular one?
Yeah, so I am not an immigration specialist or a con law person. My specialty is critical race theory, and so that's the lens through which I'm looking at the executive order. In particular, I'm interested in the language of the visa order, which goes back to what Professor Saucedo started us off with. I think that this is meant not only as a piece of legislation or an order that's going to do work in the world, but it's also meant to tell a story. It's meant to give us a narrative, and that narrative is about fear. The very first paragraph, or paragraph 2, says numerous foreign-born individuals have been convicted or implicated in terrorism-related crimes since September 11th, 2001. And then there's a tiny mention of the reasons why refugees come to the United States for asylum: deteriorating conditions in certain countries due to war, strife, disaster, and civil unrest. And then immediately goes back to terrorism. So the sentence fragment in this paragraph that mentions the purpose of asylum and refugee law, to protect people who are fleeing from war, strife, disaster, and civil unrest, is sandwiched between 5 repetitions, the word terrorism or terrorist before it, and 2 repetitions immediately after it. After that, we have a paragraph immediately following, which is the one that Professor Saucedo quoted, that the United States must ensure that those admitted to this country do not bear hostile attitudes toward it and its founding principles. The United States cannot and should not admit those who do not support the Constitution or those who would place violent ideologies over American law. In addition, the United States should not admit those who engage in acts of bigotry or hatred, including honor killings, other forms of violence against women, etc. So this order, with its multiple uses of the word terrorism or terrorist and its reference to 9/11, is sending the message that we as Americans should be terrified, afraid, that we need protection from enemies outside and inside. And it's telling us as well who those enemies are. That is, foreign nationals, inside and outside our borders, who don't support our Constitution. We can argue that this order doesn't target groups explicitly on the basis of race, national origin, or religion. It's all about identifying individuals who are dangerous. But we know, because Trump told us many times during his campaign, that he intended to, quote, ban Muslims from entering the United States. And further, the order draws on a long and notorious history of race and gender tropes to start its educational process. The order pushes many of the conventional race buttons, one of them being the idea of belonging. There's them and there's us. And second being the idea of status. They are violent, criminal, and hateful. We are peaceful, law-abiding, and good. And third, the order pushes the button of stereotyping. They are not only violent, criminal, and hate the Constitution, but they treat their women poorly. And this is a constant theme in liberal societies trying to psych their citizens up for war. Professor Saucedo was using the example of China's exclusion as one of those instances. We could also look at the runoffs to the First and Second Gulf Wars, the invasion of Iraq, the incursion into Afghanistan. In all of those situations, we saw a sudden concern with women's rights in the countries that we were planning to go into. Laura Bush, for example, famously begged Americans to believe that the fight against terrorism is also a fight for the rights and dignity of women. So this is a trope pushing buttons that attach to ideas about race as well as ideas about gender to project the notion that we are surrounded by enemies, that the president is going to protect us from those enemies. Last comment that I want to make, because I'm out of time, is that one thing we can expect to see as more people are educated by this project are what we could think of as patriotic hate crimes. So just recently, yesterday, I got this crime alert from the UC Davis Police Department that unknown individuals had left a package of pork tenderloins on the front doorstep of an apartment whose residents are Muslim. As Munir Ahmad at Yale Law School has written, creation of an internal enemy frees Americans up to channel their own individual acts of harassment, bullying, and violence towards socially approved scapegoats. And so I can predict we'll see much more of this kind of behavior as we go forward.
Thank you. So now we've heard both constitutional law arguments as well as historical arguments about the executive order and the different issues that they raise. Let's now turn to an international law perspective. And so, Professor Bennoune, can you give us some your views about the executive order? What have other countries have said about the executive order?
So taking the order of January 27th on its face, that is to say that it is in terms of protection from terrorism, I have a few things to say about that as a human rights lawyer. I'm both deeply concerned about the human cost of terrorism and potential terrorist attacks, and also of counterterrorism, or I should say putative counterterrorism policies that violate international law. Under the International Covenant on Civil and Political Rights, which the United States has ratified, states must both respect and ensure rights. This is not a redundancy, but in fact two important aspects of human rights protection. In the face of threat of violence by non-state actors, states must ensure protection from that terrorist violence as a matter of human rights itself, but they must also do so in a way that respects and does not violate human rights norms, including those norms that protect freedom of movement and the right to non-discrimination. And I fear that the executive order of 27 January entitled Protecting the Nation from Foreign Terrorist Entry into the United States fails on both counts. I fear that it will not guarantee security and may be more likely to raise rather than diminish the threat of terrorism. And I believe that it is violative of the international human rights law obligations of the United States. In the limited time that I have, I will address the human rights concerns, and I will do that by sharing with you the views articulated by various UN officials and experts, all of which are excerpts from longer statements that you can find online. So I begin with the January 30th statement of the UN High Commissioner for Refugees, Filippo Grandi, who underlined the UN Refugee Agency's position that refugees should receive equal treatment for protection and assistance and opportunities for resettlement, regardless of their religion, nationality, or race. And at that time, the UNHCR estimated that based on average figures for the last 15 years, that some 20,000 refugees in precarious circumstances might have been resettled to the US during the 120 days to be covered by the order. You can also look to the statement of UNICEF, the UN Children's Fund, about child refugees that might be affected by the new policy, something that should be of grave concern. UNICEF said the needs of refugees have never been greater. Worldwide, 28 million children have been uprooted by conflict. They need our help. The United States has a long and proud tradition of protecting children fleeing war and persecution. We trust that this support will continue. You can look also to the quite strong statement of the UN High Commissioner for Human Rights, Zeid al-Hussein, who used Twitter, which seems to be the new mode for communicating about these issues, to indicate that discrimination on, and I'm quoting, discrimination on nationality alone is forbidden under human rights law. The US ban is also mean-spirited and wastes resources needed for proper counterterrorism. I turn to the January 31st statement of the UN Secretary General, Antonio Guterres, who delivered the following statement while he was traveling. He said, "On my way back from Ethiopia, the largest refugee hosting country in Africa that for decades has been keeping its borders open to hundreds of thousands of refugees from its neighbors, many times in dramatic security situations, I want to state the following. Countries have the right, even the obligation, to responsibly manage their borders to avoid infiltration by members of terrorist organizations. This cannot be based on any form of discrimination related to religion, ethnicity, or nationality, because that is against the fundamental principles and values on which our societies are based. And that triggers widespread anxiety and anger that may facilitate the propaganda of the very terrorist organizations we all want to fight against." On February 1st, a group of UN human rights experts said together that the executive order of 27 January breaches the United States international human rights obligations, which protect the principles of non-refoulement and non-discrimination based on race, nationality, or religion. These were the experts on migration, racism, human rights, counterterrorism, and freedom of religion. They said such an order is clearly discriminatory based on one's nationality and leads to increased stigmatization of Muslims. Thank you.
I know many of you have questions about this particular executive order, and I hope that you'll raise them during the Q&A. But it's also important to understand the other two executive orders that were issued and also quite marginalized because of the more recent executive order. So we wanted to spend time talking about them, and to start us off, we have. Let's get my notes. Maria Blanco, can you please give us your comments on the executive order and interior enforcement?
Yes, thank you. Well, first thing I want to say is that we should never forget how President Trump kicked off his campaign day one, which he talked about Mexicans being rapists and criminals, that he would build a wall, and that he would build a deportation army. And that's what we basically have in the two orders that are about interior enforcement and about border enforcement. I think there is a grave issue about humanitarian refugee, with the humanitarian refugee crisis and with the visas. But I don't want us to forget that what we're talking about when we talk about the interior and border enforcement is potentially the deportation of 8 million people. 8 million people who live in the United States that are our neighbors. So, let me talk a little bit about the interior enforcement. Up to now, we've been operating under enforcement priorities under President Obama. that prioritize persons with criminal convictions. Now, you could say, and I will say, that many people thought his enforcement priorities did not get followed, that the deportations went and reached people way beyond those who had criminal convictions, and in fact, the largest number of deportations have ever happened occurred under President Obama. That said, the new priorities under this new administration include persons convicted of any criminal offense, not felonies, not violent felonies, convicted of any offense, charged with any criminal offense, just that could mean shoplifting, it can mean DUI, committed acts that constitute a chargeable criminal offense. Okay, so we've lost all concept here of due process, and of, even though this is supposedly meant to, the preface to this is to protect against criminal aliens, this extends, the crime is now being in the United States unlawfully. That's what this really means. To make sure that it means that, the Interior Order calls for 10,000 additional immigration officers. That's ICE agents in common speak. 10,000 new immigration agents. It also calls for civil penalties and fines against any person who's here unlawfully and against those who facilitate their presence. No definition of facilitate their presence. Okay? I think maybe our center, Undocumented Center, facilitates the presence of undocumented aliens because our students are DACA students who came here unlawfully, or they wouldn't have DACA. So we need a collection for our fines. The other thing, which is part of building this army, is trying to encircle people, in a sense, and strip away any support. That's what the fines are made to do. And also, there's a provision in this that's called the Privacy Act, which to me was chilling, which says that agencies shall, to the extent consistent with applicable law, ensure that their privacy policies exclude persons. In other words, privacy laws will not include persons from the protection of the Privacy Act regarding their personally identifiable information unless they're U.S. citizens or permanent residents. So now you have a category of people whose privacy is gone. You have fines, you have no privacy, you have 10,000 ICE agents, and we have the possibility of DACA being repealed with all that privacy information that's now no longer protected by the Privacy Act in the hands of the government. I want to say, the other thing that's in here, which I don't think you're going to cover, Dean Johnson, is the wall. Now, the wall, you know, I think many of us thought it was a rhetorical device, and it was. And in fact, it had a big, if you watch the rallies, there was a call and response. When are we going to build a wall? Who's going to pay for it? Mexico. Well, the order for border enforcement actually calls for an immediate plan to design and construct a physical wall. So those folks who said, no, the wall might be drones and electronic, no. This is a physical wall that's called for. And it says that the head of each executive department shall now identify and quantify all sources of direct and indirect federal aid that's been given to the government of Mexico over the next 5 years. What do you think that's about? We're gonna pay Mexico. I should say we because I am a dual citizen. Is gonna pay for the wall. So I want you to remember that this is not just rhetoric, that this is actually gonna impact the lives of many, many people, including people that sit beside you in the classroom and live next door to you.
Thank you, Ms. Blanco. Dean Johnson?
Sure, I'll try to be brief. I have 4 minutes. NPR is more generous with their time, so this is I'm going to talk a little bit about interior enforcement, and there are 2 orders. issued by President Trump on January 25th that really bolster border enforcement and build on stories that candidate Trump told during the campaign, stories that Maria Blanco alluded to about Mexicans as criminals. Mexico is sending their bad people to this country. Mexico is sending these bad hombres to this country. It builds on all these stereotypes and these visions. And the wall fits into that as well. We have to wall ourselves from evil. We have to separate ourselves from people who aren't worth becoming Americans. One thing that's important to remember about the wall, by increasing the wall, expanding the wall, one thing that's clearly going to happen is that people are going to die trying to evade the wall, and as they go through deserts and mountains where they're more likely to die, and we have people dying daily. We have somebody dying in the border regions. In some places in Arizona, there's not enough freezers to keep the bodies in the summertime. It's very human impacts. But the important thing to remember is that President Obama deported more people, more non-citizens than any president in the United States history. And 95% of those year in and year out were Latinos. And he perfected a Latino removal system that President Trump is promising to expand, build upon, and make even more Latino in terms of its removals. And if you look at the kinds of impacts that the order is going to have, the magnitude of the people affected, the first two orders are going to affect dramatically the largest number of people. I'm not saying that the third one is a good order, but the first two really are going to have a big impact on migration from Mexico and Central America. And three things that I'll mention that President Trump did in his executive orders. One is he decided to broaden the scope of criminal removals from what President Obama had done. President Obama had a program in place, Secure Communities, that required state and local governments to assist the federal government in immigration enforcement. President Obama narrowed that program a couple of years ago, November 2014, adopted a priority enforcement program that focused on people who had criminal convictions for serious crimes. As Maria Blanco just described, conviction is no longer to be necessary for deportation. Arrest can be sufficient for deportation. So President Trump's going well beyond the narrower scope that President Obama had adopted, even though President Obama deported more people than any president in U.S. history. So President Trump's bringing back secure communities. President Trump is also bringing back what are called 287G agreements. Those are agreements between state, local governments, and federal government to facilitate enforcement of the immigration laws. President Obama got rid of those programs, 287G agreement. He did so because there was some abuse at the state and local level in terms of racial profiling of people in particular communities. You may have heard of the sheriff in Arizona, Joe Arpaio, who is well known for using racial profiling in his immigration and criminal law enforcement. He had a 287G agreement. He had training on immigration enforcement from the U.S. Department of Justice. After the Justice Department sued him, got an injunction, the Obama administration decided to get rid of these 287G agreements, first with Maricopa County, then with other jurisdictions throughout the country. President Trump's going to bring that back. One of the most damaging things, and this is ultimately very depressing, the last thing is that President Trump is going to expand the use of detention in immigration enforcement. President Obama detained more non-citizens than any president in U.S. history, and President Trump wants to go beyond that. He's instructed the various immigration agencies to look carefully at building more detention facilities along the border, making immigration judges go to the border to process cases, expedite removal of those people. And he's said that he wants to end catch and release, a fly fisherman's term, but one that he uses to refer to non-citizens in detention. What does that mean? It means that, well, oftentimes if you have an immigration court hearing, you can post a bond and be released from custody. You don't spend all your time in detention waiting for your hearing. He wants to end that, keep people in detention, and that's why he needs to build more detention facilities. A lot of times people who are in detention in remote locations are more likely to throw in the towel and not pursue an asylum claim or other kinds of claims to relief and end up getting deported. So this whole system that's being set up is trying to maximize removal numbers and to get people to throw in the towel, get people to give up, and that's why it's so important that we think carefully about what's being done.
Thank you, Dean Johnson. So my remarks will be focused on sanctuary cities, and I'll limit my own time to make room for Q&A. The executive order makes a broad statement that the federal government gets to decide what would constitute a sanctuary city. On the one hand, there is no consistent definition of what might be considered to be a sanctuary city. There are some cities that are broad, that have issued broad statements of inclusivity. And then there are other cities that have said that they will not cooperate with the federal government in terms of providing information about their residents' undocumented status to the federal government. Some cities have also refused to detain non-citizens for purposes of enforcing immigration law. And so those have been called resisting to detainer agreements. And so those are the two main components of sanctuary cities, and those are the types of actions by states and localities that have caused President Trump and other supporters of his supporters to try to defund sanctuary cities. There are two constitutional questions that the defunding of sanctuary cities raise. One deals with the anti-commandeering principle in the U.S. Constitution, and second deals with the use of the spending clause. So let me just talk briefly about these two. It's important to understand the scope, what the statute currently says at the outset. So let me just read that to you. Section 1373 of the Immigration and Nationality Act says that notwithstanding any provision of federal, state, or local law, a federal, state, or local government entity or official may not prohibit or in any way restrict any government entity or official from sending to or receiving from the Immigration and Naturalization Service, DHS today, regarding the citizenship or immigration status. So let me emphasize this again. It says may not prohibit. The reason why that language used may instead of shall is because of the federalism system that we have. The federal government cannot commandeer states and local governments to do the work of the federal government. And so it was intentional, right, that the word there, it preserves the constitutionality of 1373 to encourage more state and local government cooperation or agreements, as Dean Johnson noted. But they cannot be compelled to do the work of the federal government. So to the extent that the defunding sanctuary cities is being done in order to try to issue some kind of a command to the federal and state governments, that particular charge will be challenged. Second issue deals with the spending clause. Of course, the federal government can attach some kind of a condition on the way that this, federal funds may be used. Federal funds that are being given to state and local governments. And historically, there have been ways that the federal government may withdraw some funds as a result of their criticism of the way states and local governments have used those funds. But according to case law, the use of the spending clause cannot be done to unduly coerce state and local governments to again do the kind of work that the federal government should be doing. And importantly, any kind of a defunding would have to be germane to a particular federal statute or regulation. So those are the two key components or criticism that can be made against this particular executive order. So ultimately then, we've touched on the main points of the three executive orders. We only have 10 minutes now. We'd love to hear thoughts. And so I think what would make sense of our time is we'll take some comments and questions, 3 or 4 at a time, and then we'll each respond, and then we'll open it up again. So are there any questions or comments from the audience? Yes.
With what Professor Harris said about the rhetoric leading to wars, do you perceive that this is that we're being led towards another war?
Okay. Thank you for that. Other questions? Yes.
First, they're talking about different arguments that they're making, either statutory or constitutional. And Professor Saucedo was talking about how there's the federal, or in this case, the executive branch has so much plenary power, that's what they're relying on. What do you think are the strongest arguments against the refugee ban?
Thank you. Yes.
I'd just like to make an announcement that we're having a rally in Memorial Union February 9th at 12 in support of UCD academics that have been affected by this ban. And there will be people there sharing their stories. It's going to be emotional, so be prepared.
Thank you. Yes, ma'am.
How would encouraging our our county board of supervisors to denounce the immigration ban be viewed?
Thank you. Okay, why don't we take those? So, Professor Harris?
Well, so for the question of whether we're being led into another war, I think Maria Blanco and Dean Johnson made a persuasive point that we are definitely engaging in a war against some of our citizens, unprecedented number, in fact. And as to external wars, it's hard to know. I think all of us have been sort of puzzled and blindsided by the actions, the very fast actions of the Trump administration. And he has shown aggression towards so many countries and entities and individuals. It's difficult to know whether we are in the midst of a planning for an external war. But it's certainly, I believe this effort, this education or propaganda effort certainly lays the groundwork for that.
So, and this is an open question to the panelists as well. Strongest arguments?
Oh, I think on the visa side, the statutory argument. I think on the refugee side, probably the Establishment Clause, for two reasons. One, the Establishment Clause, unlike equal protection, has a bit more of a structural aspect to it, and so it's more of a structural constraint on what government can do as opposed to an assertion of an individual's right. I think in both cases, much will be won or lost based on how novel the court sees this action as being. That was certainly true within many of the gay rights cases, for example, where Justice Kennedy seemed moved by the novelty of laws like DOMA, and I think we'd have something similar here. Insofar as this really seems like a departure from previous kinds of restrictions, then that would be convincing. But much will turn, as you say, on whether the plenary power doctrine survives and in what form, and that's something in which Dean Johnson and others are the real experts.
Can I just have a follow-up question to that, and maybe the other panelists can also address it? In my immigration seminar last week, we were trying to go through standing questions with respect to these individual rights arguments. What about non-citizens who have yet to apply for a visa to come to the United States? Is there a way for them to raise these particular arguments? And so, Professor Saucedo, you began with the plenary power doctrine. I'm talking about those not from the 7 countries, but others who want to come to the United States. Can they have no way yet they haven't yet applied. Do they have a claim?
I mean, I think there are cases that talk about due process and procedural due process and opening that up, right, to people who are at the border seeking entry or seeking admission, right? But historically, those are the folks who have had the least amount of individual rights protection when up against plenary authority. So I agree with Professor Soucek that it depends on I think it's going to look we're going to look at the novelty of the argument that the government is making to determine whether there's overreach there.
Yes.
So just to take the question about the strongest arguments against the refugee ban, I think one of them is that we are punishing many of the victims of the very same movements we say we're trying to sort of oppose the violence of in the very policy, and this is really nonsensical. I think a very important argument to be made strategically, and the UNHCR raised this in the rest of their statement, has to do with the rigorous security screening process that refugees go through before they can come here, and there seems to be a lot of confusion about this. And a third, which I think is a bigger sort of long-term strategic argument, has to do with the impact of these policies on the perceptions of the United States around the world and how that will affect security as well.
Thank you. So thanks for the information about the rally. When is that again?
Thursday, February 9th, 12 to 1.
Thank you. Okay. The question about Board of County Supervisors, I think that raises a larger question about what you can do, right? What are some specific actions that one can make to address any of these executive orders and other executive orders that might come to pass? So I'd like to turn it over to Maria Blanco and Dean Johnson to give us some thoughts about any advice that you might have for others.
Well, just briefly, I think if we are going to see massive deportations, cities and counties and states have to step up, the state of California is stepping up to provide deportation defense. The people that are going to be deported are people without means. They're going to have lawyers. Those lawyers cannot, the nonprofit organizations that exist are not going to be sufficient to handle these large numbers of people that are going to be in detention. So I think that we're going to have to build a legal network, a rapid response network, but that's going to need funding. It can't all just be pro bono. And I think that we're going to need support from cities and counties to not only help fund that legal defense, but to also create, and I don't mean safe spaces in a rhetorical sense, I literally mean there has to be a way to respond quickly when people are are arrested. There have to be mechanisms in place to deal with the folks that are arrested on a mass level.
I do think that there's action at the state and local level with respect to protecting immigrants. And there is a role to be played for the state and local governments when it comes to immigration. State and local governments are supposed to be doing their best to try to integrate all members of the community into the community. The federal government is supposed to be principally concerned with admitting immigrants and deporting immigrants. And so there's a lot of room for state and local governments to be involved. Maria Blanco has mentioned one of them. There's a number of bills pending in the California legislature. I know there was a hearing a couple weeks ago. There's going to be hearings in a couple more weeks about providing resources so that immigrants in removal proceedings can get counsel or be guaranteed counsel. It's incredibly complex, the body of law. Without counsel, it's almost certainly the case that you're going to lose. And I think that putting pressure on state and local governments to try to support immigrant communities, volunteering to help immigrant communities. Actually, our immigration clinic has done incredible work, and Holly Cooper and Magda Perez and the students. I couldn't believe they were at the airport the day after the January 27th order, helping people. But I think that it's going to require a lot of work by a lot of people, volunteer as well as political.
Yes.
Yeah, I'm a faculty member in Chicano Studies, and many of my students are undocumented. In Hart Hall, there is ethnic studies. Many of our students are undocumented. How can we put pressure to UC Davis, the administrators, the chancellors, to Napolitano, to create that safe space that you were talking about, to be at the university, to send a stronger statement? Because they are the ones who have to create the privacy for our students, who have to step up. And I don't see that happening right now. Because their families are the ones who are those immigrants. They're the ones who are in my classroom, the ones who sit beside us. And they are part of our community, of our UC Davis community. And they're some of the first ones who are going to be deported. So what can we do to support part of our campus community?
Well, there is I think, the first step has been taken, which was the statement of principles by the University of California about not turning over records or persons to ICE and not having campus police enforce immigration law. So that statement's on the books. Now what has to happen is, what does that statement look like in practice, right?
It's very fluffy.
It's fluffy, yeah. I mean, but the reality is that protection is, unless you really get into the real meaning of protection, which is legal money for lawyers, it's always going to be fluffy. I mean, what really stepping up means is funding lawyers, funding legal services. The students that will lose their DACA if DACA is repealed, and we haven't even talked about what's going to happen if DACA is repealed, will lose their ability to work, which means they won't be able to pay for school. There's going to have to be a need to have funds to replace the income that students will lose when they won't be able to work if DACA is repealed.
That's being discussed in the legislature right now.
Can I just add, that I think that, that part of this teach-in is part of creating that safe space in our communities, right? I think we need lots and lots and lots of community education about what is it that Trump is saying, what is it that these executive orders are saying that are litigable, right? So the provision that Maria read about privacy and about the federal government defining what privacy is, the federal government doesn't get to define what privacy is under the Constitution of California.
That's right.
Okay? So the more that that's out there, the more we create the pressure and the support for the legislature, for Napolitano, for our chancellor, whatever, to say, yeah, when it comes down to the actual issue of what kind of information we're going to be able to provide or not provide, we've got issues, litigable issues, right? We're not going to take the word of the federal government or this executive order about what is private information and what is not. So that's an example, I think, of how we start to create the spaces of protection or the safe spaces within our communities.
It's also important to highlight social movements, the role that social movements play in changing legal norms and cultural and social norms. Right, Che Chang-ping was decided more than 100 years ago, and equal protection doctrine, due process doctrine has changed remarkably since then. But that, the courts do pay attention to what individuals and groups are saying. And so to the question about what else we can do, because we are unfortunately out of time, I do want to highlight the powerful role that individuals have played historically, the role they can play today in terms of changing legal norms and social norms regarding this particular issue, but also other issues as well. Please join me in thanking our panelists.